Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. It's 2023. Happy New Year to everybody. We're back in the studio for the Military Justice Today podcast. I'm Matt Starosiak, stepping in just momentarily for our important host, Mickey Williams, Robert Capovilla, and we're fortunate enough to have Dan Higgins in the studio today. Dan, you've been here before, but not all that much. Probably do some more in 2023, but it's great to have you here. Great to see you.
Excited to be here. Thanks, Matt.
Matt, I have a serious question for you before we get into our pre-topic conversation. You spend a lot of time at our law firm. You know all the people that work for us and with us. Who has a better stash, Dan or Josh? On the spot right now, answer the question.
Look, Josh is a badass dude, okay? So I would never say anything derogatory, but Dan is highly trained.
Dan is highly trained.
This man,
you're in danger with Dan sitting across from you right now.
And he can get me from a distance.
He
too.
Can. He can.
From an awful long way.
You don't know this, but he's got a shotgun pointing right at your groin.
So I'm not going against Dan under any circumstances on anything.
So just
Whether
so we're
it's a
clear,
mustache
you think Dan's mustache is better than Josh's?
Well, today it is.
Whoa. Oh, man.
Hey,
dude, Matt throwing haymakers at the firm.
I don't know if I can compete with Josh's Wyatt Earp mustache.
He is.
Josh is the Wyatt Earp of the firm.
He's straight up 1865.
Yeah.
With that stash. Yeah, there's no doubt about it.
Yeah, that's a fan favorite for sure. But no, honestly, you'll never hear me go against Dan. Even in our text messages that we have back and forth, you always see me support him.
I get a lot of support from Matt on the text. Yeah, I appreciate that.
That's true.
I appreciate that.
Yeah, I'm not gonna cross a guy like that. I mean, I love Mickey. You know, Mickey. Yeah. I'm very fond of him.
I love you too.
Cap, you and I do okay together. But Dan, he's the guy. So it is great to have you here. I know.
Thanks,
you did some traveling over the New Year, right? You want to tell
got
us
out
a
to
little
the
bit
mountains.
about where you
got
went?
out to the mountains in California and Tahoe. Did a little skiing with the family. It was a nice little break.
A lot of snow out there, I'm assuming.
A lot of snow. Yeah, we almost got snowed in. Almost didn't make it back, but it was a good break.
Yeah.
You almost didn't make it back, Dan? I find that hard to believe.
Well, yeah, no, it was.
You're pretty resilient.
We had to, get the snow plow, plow out the driveway. Luckily, we had the county bring up the snow plow up the road, and we were able to get out. But
you would have been like Stallone and Cliffhanger.
Got the kids and everything, dragging them through the snow. Yeah, no, it was pretty wild, but no, it was a good time.
So you just got back, right?
Just got back.
Yeah.
Now preparing for litigation next week.
There you go. Right back into the mix. Well, it's great to have you in studio. It's always great to have other members of the firm or guests. I mean, obviously, I'm sure folks love hearing from Mickey and Rob and myself. Not really, but it's always nice to have other people and get other opinions. And we've got a great topic today, which is how to defend against drug allegations in the military. And I think these are really, really common, right? I mean, you guys certainly see them a lot. Perhaps no more common than they are in society in general, but the firm does quite a bit of this work, right?
Yeah, we do. And, when we're talking about drug cases, there's a variety of cases. Are we talking, a failed urinalysis to where, a drug was in the system? Are we talking about drug possession, drug distribution? But I think that what we see the most often is these failed urinalyses where, service members are accused of having drugs in their system.
Yeah. And so we're going to cover that in depth today, kind of how these things start out, what implications it has for that service member, what are the possible defenses, what advice you would give to folks that are going through this process. So I think it'll be a great episode. We'll obviously get all three of you in on it, but Dan, I think we're going to run with you for the most part. And so let's start out. I'll let any of you guys take this, but how do most of these drug cases in the military start off? I mean, I think it's pretty obvious what happens, but what kind of notice does that service member get? What's the first inkling that they have that there's a problem? And then we'll start to progress for where a case might go from there.
Well, typically, most of the drug cases we have, as Dan kind of alluded to, start off with a failed urinalysis. Soldier, sailor, Marine, airmen take a urinalysis at their unit, and it comes back that there is a controlled substance found in the body of the particular service member. And I would say probably about 7 times out of 10, that's how the cases that come to our office kick off.
And I'm sure everybody who's listening to this knows the answer, but these tests are done on a schedule. They're done randomly. They're done based on suspicion. Does everybody just get tested as it's routine?
Yeah. Well, there's a number of ways a service member could get tested for drugs. The first one is the random test. And that's usually the command has a quota they have to hit each quarter or so. It could be 30%, 40%, it could be 100%, whatever it is. And then that percentage is then placed against the roster that they have of service members underneath their command, including the commander even. And then they do this randomized test. That's usually how it does. But normally what happens is everyone typically understands that when you come back from a block leave or an extended leave or an extended holiday, for instance, the 4th of July, you get a 4-day weekend and stuff. Everyone kind of knows that when you come back, you're probably going to get tested at 100%. Those are the random tests. They call those inspections.
Yeah.
And then you have the probable cause inspections, right? So when the command has probable cause to believe that you've abused illegal drugs, then they can also order you to provide a sample. That is something that can happen as well. But those are unique cases, and that doesn't happen as much. Typically what happens is a guy or gal returns back from leave, they get tested, and they pop hot. That's what it's called, popping hot.
Or if you're Mickey was known in our unit for volunteering to give his urine. It was rather awkward and odd sometimes, but even when Mickey's name wasn't called, he'd be like, "Hey, sir, can I go ahead and pee in the cup?"
Yeah.
I don't know how to explain that, but that happened.
I want to show how clean I was.
That's right. Natural.
Good thing they didn't test for steroids, man.
I think the term is al natural.
Yeah,
right?
that's right. Natty.
All right. And so then what is the process? And perhaps we don't have to talk too much about how this actually happens, but what's the process for collecting and storing? Because I'm assuming that becomes part of a defense strategy in at least some of these cases.
Yeah, so there's a number of ways to defend these cases, but one of the first things that we look at is how the test was conducted, because they have a regulation they have to follow, right? And if they do not follow that regulation, that could bring into question the entire process, because what you're looking for when you're talking about a positive drug test that the service member is claiming there's no way that they used drugs and they have no idea how it got into their system, then the only real explanation could be contamination.
Yeah.
Somehow the sample was contaminated, or somehow
switched,
whatever it was. It's not their sample. So you look at how these tests are done. And typically what happens is that, and every service member knows this, every service member has gone through, even if you're an ROTC, this is how it works, right? So you go in, you stand in line, you drink a bunch of water, you get up to this person called the UPL, that's the unit prevention leader, and you give them your card, your ID card, and then you got to sign your name on some stuff. You got to like put your initials on a couple of labels, like a red label, and then the label that actually marks the bottle. And in exchange for your ID card, you get a cup, right? A cup that you're going to urinate in. Then at that point, you go with an escort who escorts you, holding the cup above your shoulder, because they want to make sure that you're not messing with it. And you hold this cup above your shoulder and you walk into the bathroom, and then the escort leaves you there. And then there's this person called an observer. And this guy or gal has to actually watch you urinate in the cup.
Sure.
They got to see your penis, or they got to see you squat down and do it. And if they don't, well, that could be a cross point, right? So they watch you urinate in the cup. It's got to hit a certain level, right? And then you put the cap on the cup, and then you walk back out to the UPL, give the UPL your cup, and they make you watch them put the label on. The red label is called the tamper tape, the red tamper tape, and that's to make sure it's never opened, right? And then they give you your ID card back, and then they're supposed to take that cup and put it in a bag, like a plastic bag. And then they take that bag with the cup and they put that in a box. and the box holds about 12 samples. And so you might be like, well, why did I put it in a bag? Why did I do all this? Because there was a case not too long ago that showed that you can get cross-contamination in the box
Sure.
if it's not sealed, if not each individual sample is sealed because of leakage. It's called leakage. So urine can actually leak out.
Yeah, of course.
And contaminate other samples, right? So that's kind of how that works. Then they take that box and they ship it out.
Yeah, and I'm sure this process, for anybody who's been in the military, for me, it kind of sounds, it's a strange process because I've never been in the military. But for you guys and people that have been in the military, this is kind of a routine thing that happens. But I think it is interesting to talk about how it's collected because I'm assuming, and we're going to get to it in a minute, I'm assuming that that provides a lot of areas for defending against these.
They do. One of the things that is true is every step of the process is subject to human error.
Right.
Every single step of the process. Now, we'll talk more about defenses, here in a few minutes. But to Mickey's point, it's about 4 or 5 years ago now that I think it was Tripler Medical Center had a major issue with contamination where the Army had to send out Brady notices for every drug case that they had preferred charges on, if I remember correctly, because they had a massive leaking issue that either occurred during transport or storage. I forget now. So that does happen. And one of the ways you can tell potentially if there is leakage is when you get the results of the drug test, you're going to get the results of other people's who were taken in the same sample group as yours. Now, they're going to be, those names and DOD numbers will be redacted. But if there's multiple people from the sample group who tested positive, there may be a leakage issue. That could be an indicator that, urine leaked onto different samples or however that process works. But that's not, by and large, that's not very common.
No.
We haven't seen it happen now in at least a couple years.
But
Yeah,
suffice
that's right.
it to say, there is a process in place. It sounds like it's designed to be a strict process that produces accurate results. I mean,
Yes.
Yeah.
And which is, it makes common sense that you would do it that way.
And the reason for that, Matt, is because, believe it or not, if this case goes to a trial, which happens every day, right? The government does not have to prove how the stuff got into your system. They don't have to prove your intent when you did all this stuff. It's enough to have a positive drug test, and they can infer all of this stuff based on the instructions because the way the law looks at it, it's too difficult.
Yeah.
Otherwise, right? It's too difficult. So, but what the courts will scrutinize is how you collected it, right? Because that, if you didn't do that right, then you got some problems with the chain of custody and everything else. So,
All right. Well, I think that's a good amount on the collection process. Let's transition now into something happened. Somebody's, what do they call it? Popped hot, tested positive. Yeah. What happens at that point? Does somebody get flagged? Do they get noticed? Do they get pulled into a room? How does that next phase start where I guess the service member receives notice that, hey, something's up?
go ahead, Dan, if you want.
Yeah, what oftentimes happens is they're pulled in for, a counseling session, right? Like, it comes back, and they're told, hey, you tested positive for, whatever substance. That commander, that first sergeant, that first shirt, whoever, will bring them in, counsel them on, the fact that they tested positive. And then there's going to be a couple steps that happen going forward, right? They have to initiate separation against a service member if there's a failed urinalysis, right?
It's automatic. It's
automatic. Now, that doesn't mean that they actually have to go forward and finalize the separation and actually kick the service member out, but they have to at least initiate it. And then an investigation can take place as to, what's going to happen, as far as whether they thought that, the service member intentionally ingested it. And that's something we can kind of get into as far as, because, a failed urinalysis by itself is not evidence of misconduct. It's not a crime, right? They have to prove that the service member intentionally ingested the substance, whatever it was.
Yeah. Well, let's go back to this meeting, this counseling session, because I think there's probably some pitfalls and obstacles that you would want to avoid if you're brought into one of those. But how does it happen? Is it literally one of your senior command brings you in and says, hey, I need to talk to you, and takes you into a room and talks to you? And then I guess the other obvious question is, you probably don't want to say anything at that time, right? Do you have to be careful what you say? Because at that
Absolutely.
point, from that point forward, anything you've now told your command can be used against you. Can you tell me a little bit about the dynamics of that meeting and what somebody should and should not be doing in it?
Yeah, I think it's tempting for a lot of service members to, go in there and get their side of things out on the table. Hey, I've never, done this before. I didn't touch any of this stuff. Or, hey, I went out to a party and maybe there was something, it's tempting to go ahead and get your side out, because you feel like you're innocent and you didn't knowingly ingest this. But it's really best to just remain silent. Especially with, a commander, a first sergeant, a supervisor, because yes, anything you say can be used against you, and they will use it against you.
So there's no rights that have attached to you at that point. There's an accusation made.
There is an accusation made, but if you have a failed urinalysis, that is the evidence they're going to rely upon to move forward with separating you.
Okay.
And that's, evidence they can rely on, to take other steps against you, like non-judicial punishment, like in Article 15.
Yeah.
And so that's oftentimes what they do before moving forward with separation is they take you forward to, some form of non-judicial punishment, captain's mast, Article 15, to give you that reprimand there, usually reduce you in rank or take some pay. And then they move forward with separation after that.
Okay. So all those other things can happen. Can you get removed from your job and all that as well?
Yeah, absolutely. It depends on what your job is.
Yeah.
Sometimes they keep them in position and they let them continue to work and do their job. But say you're, a parachute rigger, right? And you test positive for cocaine, right? They are not going to allow you to continue to pack parachutes.
Sure.
If you've tested positive for, a mind-altering substance like that. So yes, you can be removed from your position. We oftentimes see it happen to where they're moved up onto the staff, onto some position that's, menial, and they're not doing their day-to-day position. They're usually removed from a position of responsibility if they're in a leadership position. So yes, you can get removed from your position. You oftentimes do, and that can be even more stressful for the service member.
So there's initial implications, and then obviously there's going to be long-term implications as well from that meeting.
That's right.
We don't give legal advice on this podcast, but let's say that I was on active duty and I got dragged into that room and my command shares this information with me. What would you recommend that I do at that moment? Because obviously it's a very difficult situation, right? Because that's your command there. What would be your response or your opinion on what my response should be at that moment?
Well, your career is on the line, so you need to take it incredibly seriously, and you're going to need someone to advocate for you, to investigate the circumstances of this case. And so, my answer is you need to consult with a legal professional.
And so that's what you would tell that person that's counseling you. You would say, I understand what you've told me. I'm going to seek legal representation, not make any statements at this time.
Exactly. Yeah,
Okay.
Exactly. You can say, understand, you leave the room, go talk to an attorney.
That sounds really hard to do. Mick, really hard to do that?
Yeah, because people like to talk where they want to, especially if they didn't do this, right? Or if there's the problem is if you're told to trust the process with the command, just let it work itself out. And service members time and time again think that their commanders are reasonable, and listen, they are reasonable people, but the problem is they have a JAG speaking in their ear saying this is what we got to do. And whether the commander wants to exercise discretion or not, it's not really up to the commander. It's the legal office is running the show at that point. So it is hard to resist the urge to talk, but I'm telling you, you're just going to dig yourself into a hole if you do talk.
Yeah. I mean, that's probably, in my opinion, probably one of the most important things about this podcast episode is just that, which is you need to keep quiet initially. It's not easy to do that under those circumstances.
The worst thing that can happen to you is that you say something and then there's something out there that can contradict it, and the command has it. Yeah. Because now they're not going to believe a word that you say.
Well, and a big thing with those statements, too, is a lot of times folks are going to want to go down that innocent ingestion defense, and they'll want to get that defense out as quickly as they can. They read about it online or whatever the case may be. But the problem is they haven't looked at the science yet. They don't know how much the drug was actually found in their system, which can be a major indicator that would either support what they're saying or contradict what they're saying, right? So if you're going to talk early, number one, don't do it. But if you absolutely are going to do it, understand you're putting yourself at risk for contradicting what could otherwise be a strong defense.
Yeah. And let's not forget, you're talking to the command now, but right around the corner, you're going to be called in to talk to CID or NCIS also. So I think that's the next.
Yeah, and that's important to understand too.
Yeah.
If you test positive, you're going to be talked to by law enforcement, and it's typically going to be CID, NCIS, OSI. They are going to want to find out how that drug got into your system. And again, your best bet, as we say on here all the time, is keep your mouth shut, because you don't want to say something that's going to contradict what might otherwise be a solid defense for you. And they would, OSI, CID, NCIS absolutely will investigate you for false official statement if what you tell them contradicts what they otherwise know or think to be true. It's a delicate balance. Your best bet is to be quiet and get yourself an attorney.
Okay. Well, I think that's very wise advice. It's wise advice with any legal issue, right? I mean, especially one that has to do with your career and your benefits and everything else that's at stake. All right. So you receive notice, you're counseled, and then it sounds like an investigation kicks up and you're going to talk to additional people.
Yeah, so like any other time there's an allegation of misconduct that the military considers serious, and they do consider alleged drug use in their ranks serious, there's going to be a law enforcement investigation. You're going to be called in. You're going to be interrogated. Sometimes they even do a follow-up probable cause urinalysis, right? That happens frequently. The other thing that'll happen is if CID, NCIS, or OSI find some justification or probable cause to search your phone, search your home, we see that in connection with drug cases relatively frequently. So it's not just a unit level issue. You are now being investigated for an infraction of the law, and the military is going to use the resources and their highly trained agents to conduct that investigation.
Yeah, and they're not on your side.
No, that is an accurate statement. Dan might think that they're on his side, but they're really not.
All right, Dan.
They will crush you.
So what comes next, Dan?
Yeah,
what comes next in the process?
To kind of talk about Rob, what he was saying there, a lot of times law enforcement, they have to conduct an investigation, how these drugs got in the system of the service member. Do they believe that, the service member intentionally ingested these drugs? But what they're also doing is they want to know how the service member got the drugs. Right. Who is bringing them onto base? Who's bringing them onto post? Where are they getting them in town? Right. So then they can coordinate with local, state, and federal law enforcement to kind of track that down as well. So we see that they are interested in, the service member individually taking them. But what they're looking at, more broadly is, where's this stuff coming from? How's it getting to the systems of our service members? Yeah.
So at that point, it's not just it's in your system. It's all these other questions you're going to be asked about details of it.
Yeah. And law enforcement, they're just trying to, get some answers for the JAG, right? The legal advisor to advise the command, right? The law enforcement doesn't really care that much about the individual service member. They're looking much more broadly into the community, into the area, into trying to attack these different drugs that we're seeing a lot. Yeah. Like fentanyl, Delta 8, and a lot of other things that we're seeing.
Interesting point, and a good point. What and then what? Article 15 next? What comes after this as they move through the process? Does it move to separation? Here we go.
Well, just like Dan said, it doesn't matter if it's your first or your second or your third positive drug test, they have to initiate separation. So that is likely going to happen. Although they have the option of taking a trial, typically though, trial only comes about after the Article 15, because what happens is you get counseled, you get flagged, a CID does an investigation, you're kind of left in the dark, and then they want to give you a field grade Article 15. And if you have a very strong innocent ingestion defense, or you want to attack the chain of custody, whatever, the testing procedures, what's going to happen at the Article 15 9 times out of 10, right? The conviction rate on Article 15 is extremely high. So even if you present a very, very good defense at the Article 15, the odds of it getting acquitted, there are low. So if you go to the Article 15, you're probably going to be found guilty, which means you're going to be reduced in rank, you're going to lose money, you're going to be humiliated, and then they're going to use that to pad the packet for the separation board. So you are at a crossroads then with the Article 15, because you have the option to determine to demand trial by court-martial. And that's typically where the court-martials stem from, is when you have an Article 15 turned down. and they're demanding trial by court-martial. And what's interesting is you're also kind of calling the bluff of the command. Is this something you really want to take to trial? Right? How confident are you in this case?
Yeah.
Right? Because they might have an idea that it might not be that strong, or there might be some stuff out there. But on the other hand, a commander could be thinking, well, I got to make an example of this guy. We got a drug problem. I'm not going to let him get away. And they'll call and they'll go forward with the trial. And then that's when, all this stuff really, really matters.
And that's really why it's important to get strong legal advice early in the process, because you're going to, when I say you, the service member needs to know what kind of defense they have. If they honestly don't know how the drug got into their system, innocent ingestion is absolutely a defense. As Dan talked about earlier, it is not a crime to have a controlled substance, weed, cocaine, whatever. It's not a crime to have it in your system. It's a crime to knowingly and wrongfully take it. And with THC in particular, in today's world, there are hundreds of ways where it can get into your system. We've had people have it through popcorn. We've had people eat gummies. We've had the old brownie cases. We've had pre-workout supplement issues. If you truly don't know how it got into your system, you need to have an expert in military law look at your packet, look at the nanogram level, look at the supporting evidence, go out and interview the witnesses you were with that night to say, yeah, there were no drugs there as far as we know. Because once you call the command's bluff, like Mickey did at the Article 15, you may find yourself in a court-martial. You may be staring down the barrel of a federal conviction. So you're going to want to have your ducks in a row.
Yeah. And
it's not enough to say, well, I don't remember taking it, so let's go to court-martial. You're going to want to hire a lawyer to look at that packet critically and help you determine what's best for your future.
Yeah, understood. And a good point. But let's circle back to defenses. What are the possible defenses? And then the case strategy on the Article 15 and what you demand in that, I think, is a fascinating discussion. Maybe come back to that. But what are the potential defenses? We've talked about some of them already. Contamination is one, right? Innocent ingestion is another. Are there others?
Yeah, I think one of the most effective defenses for, drug cases like this is innocent ingestion, right? Sure, there can be, contamination or chain of custody issues, but, those are rare. What we see most often is a service member did not knowingly and wrongfully ingest this substance. I had two cases recently. One with a service member went out into, New York City and went to a party with his girlfriend, with a friend of his from his hometown. And he went out and had some brownies, some desserts at the party, started feeling very weird. His girlfriend witnessed him vomit. He went home. His mom is witnessing this behavior. And so, because he contacted us early on in the process, we were able to conduct an investigation of our own, go out and get affidavits from everyone, that was involved there. And then we presented those affidavits to his command to say, look, this does not make sense. This is a good soldier. He's a good kid. It does not make sense that he would go out and knowingly ingest this. And look at everyone's statements. Look what they're saying. And so he turned down the Article 15 and he demanded trial by court-martial. And when they looked over those affidavits, when they looked over the evidence, they decided not to go forward with the court-martial.
Which is probably the best result you could get,
the
right?
absolute best result, right? And so, Mickey talked about calling their bluff. When we have evidence like this to where, we feel confident that we can call their bluff and we can win at court-martial, then let's turn down the Article 15. Let's go forward and, challenge their accusations here.
And that's, not to interrupt you, Matt, but that's key what Dan is talking about. Building the case before you go into your Article 15 so you're making an intelligent decision on what to do. Because 9 times out of 10, you're going to go talk to an assigned military counsel, and those are great lawyers, great officers, great people. But they see these, they're focusing on the court martials. This is routine for them. They're likely going to say what? Oh, you need to go to the Article 15. You don't want to risk a federal court martial. What we've learned with experience over time is some of our very best results, some of the times we've gotten absolute victories where everything is dropped altogether is when we tell them to turn down the Article 15. If you are truly innocent, like Mickey said, and you have the defense, you may not want to go into Article 15 because Mickey's right. I don't have the numbers of conviction rates, but in my experience, which is, the last decade of doing nothing but military law, it's got to be north of 98%.
Is that right?
I mean, of all the times we've dealt with it, I don't, north of 95% at least. So if you go to that Article 15, that's fine. Understand, you're likely going to come out guilty, and then it's going to head to the set board, which you can absolutely still win a set board with a guilty Article 15 verdict. We do that all the time. That happens. But if you truly have that good defense, spend the money, get yourself the firm you need to get to put that defense in order so that you understand what your case is all about.
Another example for you, Matt, is I had another service member recently who vapes, right? And we see this so often with soldiers or, service members, sailors, Marines, airmen who vape. He's at a bar. His vape dies. He goes outside. He sees another guy out there with a high and tight who has a vape. He hits this guy's vape. Turns out that other guy was not a service member, and it had Delta 8 in the vape. So he tests positive for Delta 8. So again, he came to us early on. We conducted an investigation of our own. We went and got affidavits from everybody that was there at the bar that night. We told him turn down the Article 15, demand trial by court-martial. He did so. And then when the command and the attorneys looked at that evidence that we presented to them, they said, you know what, this guy's a rock star. He is not the type of guy that would do this. We believe him. So all he had to do, they dropped everything. All he had to do was go down to his platoon and give a class on not using other people's vapes.
Yeah, which
so
is
that's
nothing
again the absolute best outcome you could imagine. And so that's kind of what we're seeing here.
I think Mickey should give us a class at the firm about the about not using somebody else's vape. What do you think, Mick?
Yeah, I'd love to give a class about that.
That would be enlightening for us. Have Josh do some research.
I just think it's kind of gross sucking on someone's.
I think so too.
Yeah,
like that.
Matt can join us. Our producer can come join us. This would be beneficial for everybody at the firm. Don't suck on somebody else's vape.
Look,
Yeah, I'm
a germaphobe. I'm not going to touch anything in any event. But let me ask you this question, because as you were talking about
Matt,
kind
hold
of
on.
the timing.
But before we move on to serious topics here, will you attend our class on don't hit another man's vape?
I'm gonna whatever
Rob's
you want to do.
very concerned about that.
If you want to pay me to,
I
be
just
there,
think that's
I'll be there.
hilarious.
That's going to be at the safety brief now that they have on Fridays.
We've got the firm party this Friday, and a lot of folks are coming. You know what? That's a perfect opportunity.
Yeah.
You're gonna piss test everybody.
Everybody that everybody that comes
When they
in.
come in, I'm gonna have a freaking jar over my head.
That's right. We're gonna put Mickey in charge.
Eric
you go.
Eccles will be the observer.
I can no longer attend the party.
See, this is Dan. You're not on that as many episodes, but this is usually where it digresses to. But let me ask you this question: Do you oftentimes or regularly get service members call you before they've heard anything from their command, and they think they may have ingested something, or they know they may have a problem? Like, hey, I ate these brownies at a party. I've come to find out afterward that I haven't been tested yet, but I think it might cause me a problem. Do you get those calls?
No, that's very rare.
Yeah.
Usually, everyone calls us after the failed urinalysis.
So they're not too worried about it until it comes.
Yeah, they're probably worried about it, but they're kind of rolling the dice at that point. That maybe there will be some time between the time that I might have ingested something to where that urinalysis pops up if it's that random test, right? Cocaine, and some other drugs, they'll only stay in your system a couple days, right? Whereas marijuana, Delta 8, that can stay in your system for months.
Is that right?
Yeah. So, there's different timelines that service members have to worry about.
So it's really after they've been caught, so to speak, or accused.
Yeah, and we all have different experiences, but I'd say over 95% are usually after the failed urinalysis.
And the reality is, with CBD products being so prevalent now, literally almost every gas station you stop at is going to have some kind of CBD product. A lot of these service members are not expecting to test positive. It is, in fact, a surprise to them. I've seen more of that the last couple years than we have the previous 8 years combined. And it's an issue.
Yeah, the problem with that is that, when we're talking about vapes, a lot of these vape cartridges, they will have Delta 8 in them, and they're being sold at gas stations.
Right.
And they're not advertised well on the packaging. So, multiple times in the last couple months, we've had service members, they go in, they buy a vape cartridge, they throw it in, they vape, and they don't realize that it had Delta 8 in it. Some of these people, they don't even know what Delta 8 is.
Yeah.
Right? But they're, because vaping is completely legal. You can vape.
And we see that in other contexts. I mean, you see UFC fighters, they'll pop, hot for something that's in a supplement, and they order some supplement from God knows where, and the supplement had it in, and they come to find out that
their defenses typically are less credible because most of those guys are getting substances from Mexico shipped over the border to them, and they're baseball players here in the States. I mean, but in joking aside, I do think that we're seeing a lot more positive tests where truly the service member doesn't understand why they test positive. I think that's happening more and more now than ever before. I don't know what you think, Mick. You've been doing it as long as me, but we get more calls now than we ever used to, and credible calls.
Yeah, the CBD. So that's what Delta 8 is. So there's two types. You've got Delta 8 and Delta 9. A good way to think about it is Delta 8, you're great, because it's legal in the United States, but Delta 9, you're mine. That's THC. That's the one that's going to get you in more trouble than the Delta 8. I think that, morally speaking, if you have a moral opinion about it, the whole reason for not having the drugs is because of the psychoactive aspect. It takes your attention away from your duties and so on. I don't see why Delta 8 is, DOD prohibits it, but I'm not seeing the psychoactive argument as being very credible, because the Delta 8, I believe, is supposed to be there to be like kind of an analgesic. It's just a pain reliever to help you. And in the military, you got lots of pains.
Yeah.
Right? And
that's more of an overall policy issue on what could be changed, perhaps.
That's a policy issue. But to go back to the defenses, so we've covered contamination and we've covered innocent ingestion, which is the most common defense out there. There's also more of I would call it an exception to the prohibition on drugs. It's called limited use.
Yes.
And with limited use, it means that you get like one free bite at the apple. You get one free pot, as long as you come forward to the command and say, "Hey, I got a drug problem." Right? I'm struggling with this, because they don't want to penalize people or people who have issues, drug addictions. They don't want to penalize them if they truly have one. And the idea is you have to have, one, come forward, and you must not have known about a drug test that's coming up. Those are like the two requirements. But if you do that, then that drug hot can't be used against you, right? They can't use it at all in any form. But if you test positive from that point forward, right, they're going to get you.
It's an issue.
Yeah, it's an issue. So there's that as well. It's more of an exception. Yeah, but it's part of the whole drug, the drug analysis.
Yeah, but I think that's incredibly important for our listeners to know that is available and that is an option. Again, one you probably wouldn't want to move forward without the advice of an experienced attorney. Yeah. But what about the amount of drugs found? Rob had thrown out the term nanogram, which I'm not familiar with.
Right.
He throws out a lot of terms I'm not familiar with, by the way. But does the amount, is it tested? Can they tell how much is in somebody's system, and does that matter?
Yeah, of course. That's what the purpose of your analysis is, to test the amount of number one, is a controlled substance in their system? Number two, how much is there? Because each substance, right, each controlled substance in the military has a set amount or an amount that if you go over their established DOD guidelines, then it's presumed that you took it wrongfully, is essentially how that works, from my understanding. So, for example, there are times where we have clients test positive for, THC, but it's below the limit that they can even move for separation on, right? That's kind of how that process works. But by and large, when you're talking an innocent ingestion, the more of the drug that is in your system, typically speaking, not in every case, the less likely it is you innocently ingested it, right? Sure. Because if you're drinking a substance or you take some gummies or whatever, it's not going to be as much typically of that substance in your system as if you smoked marijuana, right? Had a direct hit on it or something. Mickey, I don't know if you want to talk any more about that. Or Dan, if you have any more experience on that, but certainly the amount of the drug found in your system is a fact to consider when defending these cases.
Yeah, it's very important. It's something we always want to address, right? We have a lot of these fentanyl cases lately, and addressing the nanograms per milliliter in your system is important, right? Because, if it's a very small amount, right? It can speak to an innocent ingestion, right? Through touch, through, some sort of accidental oral consumption, right? It's very, very potent when we're talking about fentanyl and other drugs. But, if it's a small amount, right, it either means one of two things. One, it was truly an innocent ingestion to where, you just came into some sort of incidental contact with it. Or two, they're catching it on the tail end, right? So it's starting to dissipate from your system over time, right? So it's something that you do want to address, whether we're at, administrative separation board or whether we're at a court martial. The nanograms per milliliter in your system, it's important to analyze.
Do you guys ever have experts involved in these cases, or is it more cut and dry than that? You can kind of look from your experience and know the science behind it and that, or do you occasionally have to get experts involved in it?
Yeah, we do. Sometimes we want to have an expert up there, especially if it's at a court martial, right, to help a panel or if it's at a board, to help the board understand what it means. Because, if we're just simply talking to you, for example, you don't know what, the differences between 0.094 or 0.34, nanograms per milliliter are when we're talking about cocaine or fentanyl. So to help break that down for them, to help them understand what it means is important. It's also important to have our own expert up there to counter maybe the government's expert, right? Because we're going to cross-examine that expert and have them explain this. And if they are off base or they are, injecting, typical government rhetoric into their interpretation of what this data means, we want to have our own expert there to counter it.
Yeah.
It's difficult. The separation board process can be frustrating for the defense attorney because the procedural due process rights that are in place at a court martial are not in place at a separation board. Getting expert assistance at a separation board can be difficult. That's why interviewing the individual who tested the drug from the laboratory before the board is very important, to let them, so that they understand that they're dealing with a civilian counsel who absolutely knows what this data means, so that if they go off script, if they start saying things to intentionally hurt your client, which they will absolutely do, right? If they're not curtailed, they will do that.
Yeah.
Sending that message early is important because when they know they're facing cross-examination at a board from an experienced counsel, they're less likely to go and say something crazy. Because here's the bottom line. The lab techs who test those samples cannot ever say whether it was done intentionally or not. All they can say is that this is the amount that was in the system. Court martial, on the other hand, when you've got a drug case at a court martial, you're going to typically be entitled to expert assistance if it's necessary and relevant. That expert assistance will be paid for by the government as long as you can show they are, in fact, necessary and relevant. So at a drug court martial, you're going to be using a toxicologist. You're going to be having your own expert who can help you prepare for that case. You're not going to necessarily have those rights at a separation board, which is frustrating. And certainly if your attorney doesn't know how to cross those experts without one of their own, yeah, I mean, that could certainly hurt you.
Yeah. Yeah.
I mean, the typical way you would do a cross on an expert for this is kind of like what Rob and Dan are saying, is you can't determine how it got there, right? That's the first thing. You can't determine when it got there, and you can't determine the intent of the person who ingested it.
Yeah.
And then also you can expand on other ways the drug could have gotten there. Right. So that
could have been this, could have been that, could have been anything.
Yeah, especially with fentanyl, because it can be absorbed through the skin. It's very easy if you're handling paper, money and stuff, or if you're at a bar, a public bar. I mean, they've done tests where they found fentanyl on the bar. Like it's all, and it doesn't take very much.
Yeah.
Right. For you, cops die all the time.
Sure.
From handling defendants who were high on fentanyl or had fentanyl on them. They have to wear these special gloves and everything when they do that because it's everywhere. I mean, it's really all over the place. So if you've got lots of options when you're cross-examining an expert in areas that you can go into, that's actually quite helpful for your case, especially at the separation board, if you have an honest expert.
Yeah. All right. Well, I think we're probably getting close to our time to wrap this up. Let me ask you just maybe a couple final questions, Dan. Where do you think this is going? Where do you think these drug cases are going overall in the military? Obviously, at least from my perspective, it seems a lot of these things, marijuana and CBD and everything else, being legalized across the country at different states. Seems like the laws have been relaxed somewhat. in other contexts. Where do you see it going? Do you see more of these prosecutions in the future? Less? More success? Less? Things are getting tighter?
I think we're probably going to see more because as it becomes legalized across the country, it's going to be easier to access, right? And I think that it's going to be a continuing issue. I do not think the military is going to lighten up on this. I do not think that they are going to, legalize Delta 8 or THC 9 for service members. Because, like Mickey talked about, there's a big difference between CBD, and Delta 8, right? CBD is often used for pain. Delta 8, it can be, mind altering. It can have psychoactive, elements in it to where it does change your ability to function, right, and do your job. So I don't see the military lightening up on that. I don't think that you can justify having service members, whether they're in an aircraft or packing parachutes or out on the, on the line, maneuvering as a squad or as a platoon, allowing people to be on mind-altering substances. So I think that we're going to continue to see a lot of these cases.
Yeah.
I think that's really well said by Dan. And here's what I'll add too. The Uniform Code of Military Justice exists in part to enforce the good order and discipline of a unit, of the military in general, right? And while I think that the military justice system is becoming more like the civilian criminal justice system every day, which is why I think there ought to be unanimous verdicts in the military system, when it comes specifically to CBD or to Delta 9 or whatever, the bottom line is that there's a reason this law exists that's directly tied to good order and discipline. In the military, folks are doing things every day. Like, think about it. Dan made a great point, packing a parachute. Yeah. You can't have somebody under a substance packing a parachute because, God forbid, what's going to happen to that poor dude that's got to jump out of the plane, right? So I don't think it's going to change either. I think it's going to be around for a long time. I would like to see a bit of an exception for medical use. Perhaps there's some treatments that can be given to these folks and pull them off their job for a while, because we do have a lot of cases of folks that have PTSD, that have serious physical pain, that are using to help with that. But aside from that, I don't see any. I don't think that change is going to happen, and I don't see any other changes coming down either.
Yeah. Well, I think well said by both of you, really by all three of you. A great show, fantastic topic. I think a very common topic. I know y'all get a lot of calls on these cases from folks that just aren't really sure what their next move should be, and probably a good opportunity to remind people that you will talk to them at no charge initially on a consultation.
Oh, sure. Be happy to chat with somebody who's got some concerns about, a urinalysis. Feel free to give us a call. Happy to have that conversation. And maybe you could even talk to Mickey. Mickey is an expert on drugs in the military.
Well, I am from Oregon.
He is.
Keep that in mind.
And he's going to be giving that class to our party on Friday.
We'll post the results of the holiday party testing at Sean's house this weekend. So it was a great episode. Dan, thanks for joining us. Did you have fun, or did we put you to sleep?
Yeah. No, great time.
It was a great episode. We're going to sign off. Matt, Rob, Mickey, and Dan, great having everybody listening.
Great having you, man.
And we'll be back with you shortly with another episode of Military Justice Today. Take care. Be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.